Hello, my name is Darren Howard. I'm one of the workers' comp attorneys at Fradin, and I'm joined this afternoon by one of our other workers' comp attorneys, Sal Popolillo. Sal works in the Greensboro office. I work in the High Point office, but we're here to hopefully answer some of the questions that we get routinely on a day-to-day basis from our workers' comp clients or our potential clients that call in. And Sal, obviously the first question that comes to mind is, I was injured on the job. I've never been through this before. What do I do to start the process?
Wow. Well, for the most part, I would say is to call an attorney, whether it be me, whether it be someone else, but call an attorney because for the most part, that attorney will do the entire claim for you and help you along the way and guide you through the process, file the right forms and things like that. But if you were going to do the process by yourself, what you should do is, one, inform your supervisor that you were injured within the course and scope of your employment while you were at work. And then two, after getting medical treatment, you should file a Form 18. And a Form 18 is, on the North Carolina Industrial Commission website. And it's pretty much just a way of giving notice to the employer and the Industrial Commission that you were injured on the job. And it's pretty standard and it's pretty straightforward. But sometimes it can be a little complicated when you are trying to do this by yourself. And sometimes you can lean on your employer for sort of help in the process. And some small companies may not know what to do. But
Well, and that's a very good point. Sal was discussing some of the distinctions we see in our practice between a small company and a large company. If you're injured on the job in the course and scope of your employment and you happen to work for, let's say, a local small company, there are some issues that I've seen repeatedly pop up. Mm-hmm. Sometimes I get the hypothetical where the employee who's injured on the job is on good terms, good friends perhaps even, with the employer. Mm-hmm. And they almost have a sense of guilt about filing that claim and proceeding with a workers' comp injury. So what I really want to tell people in that scenario is, listen, irrespective of your relationship with the employer, you need to protect your claim. Mm-hmm. Hopefully everything goes well. Hopefully you remain, after you are treated and you're fully recuperated, you remain with that company. And that is the ideal scenario. And that is what many of our clients want, obviously. But we've also seen the other end of the spectrum where we've got the workers' comp insurance companies driving the claim. Mm-hmm. They frankly don't care what the employer may or may not say about this employee. They just want to administer the claim and they want to do it as cheaply and as quickly as possible.
Right.
And so in that scenario, I had to caution a lot of people, it's admirable that you're loyal to your company. It's fantastic you've got a good relationship with that company and you want it to continue. But at the end of the day, you have to remember that it's not really the employer that's going to be making the calls with that claim. It may be the insurance company, and in all actuality, probably will be the insurance company.
Now, Darren, one of the forms that we see all the time is a Form 24. Now, this comes in after an employee starts their claim, right?
That's correct.
Okay. Can you tell me a little bit more about what it is and its effect?
Well, a Form 24 is one of the Industrial Commission forms that gets our attention very quickly, and that's because it is something that the insurance company, either through the adjuster or through their attorney, their defense counsel, that's a form that's filed against the employee. And it essentially says that, listen, the weekly compensation check that employee is receiving during his treatment phase, that we're trying to either terminate or suspend that weekly check, and we have a reason that we're trying to do that. And the reason they most commonly mention is that the employee, the injured employee, is not complying with the medical treatment. And so the example I like to give to clients or potential clients is, if you're treating and you're receiving that treatment because you're injured on the job, it's not optional. If a doctor tells you you need to go to physical therapy and they schedule perhaps a regimen of 10 appointments for you and you only show up for 3 of those, you're not complying with the treatment. Mm-hmm. Doesn't mean that you have to go to each and every appointment. You can have a valid excuse. You may be late to an appointment. You may get sick. You may have to miss an occasional appointment. But if you don't listen to your physicians and the insurance company is back here paying the bills, they're going to do something about it. So I like to warn my clients, take your treatment seriously. try to be pretty conscientious about going to your appointments, and don't give the insurance company in the background any ammunition to use against you.
Okay. Now, hypothetically, one of your clients receives this Form 24. Is there a way to fight it? Is there a way to combat it? What do you do next?
Typically, the Form 24 is sent to the attorney for the injured employee, and we receive that. Obviously, I'm going to call my client right away. I'm going to forward the form. I'm going to discuss with them the reason that was given on the form itself for the motion to terminate or suspend. And then I'm going to ask my client, how do we respond to this? We need to respond to it. You need to tell me how I'm going to explain to the insurance company and to the industrial commission that you have been complying. And so I'm going to look at your medical bills. I'm going to look at your medical records. I'm going to look at your schedule. And I'm going to try to provide documentation that shows that indeed you may have missed the occasional appointment, but for the most part, you're going to your appointments, you're listening to your physician, and you're following up with the treatment that's been recommended.
Okay, is this just something that you email the insurance company or the opposing counsel, or do you go in front of a court, or what's sort of the process there?
It's somewhat of a hybrid, and I explain to people that in this day and age, a lot of the forms that we deal with the Industrial Commission are filed electronically. In fact, the majority of those forms are filed with Raleigh electronically. Saves a lot of paper, saves a lot of time.
And you do this on behalf of all your clients?
We do that on behalf of each employee that we represent.
Right.
And so we're getting their input, but we're filing the forms for them. And then what we're doing is we're scheduling a telephone hearing with the North Carolina Industrial Commission. And so that telephone hearing is obviously much more convenient than driving to Raleigh, like we used to do back in the day. It's a lot more convenient than driving even to the county courthouse. We're doing everything by phone and perhaps even by Zoom or WebEx. So it's very efficient, but it's the same process.
Right. Okay, so it's in front of a neutral party, right? There's a decision maker there to it, right?
Very good point. The decision maker in that scenario, especially with the Form 24, would be one of the deputy commissioners that works for the Industrial Commission.
Okay, and they're like a judge.
They're like a judge. They are the decision maker. They're going to hear the evidence. They're going to consider all the documents presented as evidence. And at the end of the day, they're going to weigh the evidence and they're going to render a decision.
Okay. Now, hypothetically, does that decision maker come into play for other sort of scenarios? Like, what if someone's claim gets denied? What happens?
If a claim is denied by the insurance company, then the person that has hired me to represent their interest, I'm going to recommend that if you were really injured on the job and your claim has merit, you don't need to just take that denial laying down. You need to move forward and appeal that denial, and that's something we do via what we call Form 33. So it gets confusing. There's a lot of forms out there that we have to deal with, and they each have a number and they each have their place in the overall context. But the Form 33 is essentially the way to apply to the Industrial Commission for your day in court.
Okay, so Form 18 starts a claim. Form 24 is the employer saying we're terminating your benefits.
Correct.
Form 33 is asking for a hearing, and the hearing comes into play when you can try and combat one of their forms, or you can combat their denial, right?
Exactly. It's just like the courtroom scenario, but it's the workers' comp context. So when we file the Form 33 and we have a hearing date, of course, now most of the hearings are done remotely via WebEx or via Zoom, but the hearing is just like a mini trial. And we try to anticipate, I say we, me and my opposition, the opposing counsel, we try to estimate how much time the hearing itself is going to take. We send that information to Raleigh, we send our witnesses, we send our written contentions, and we prepare everything, or as much as we can prepare beforehand. So that way, when we have the remote hearing, a lot of times we can do the hearings in a half a day or in one day. So we're not looking at going to the courthouse for 4 or 5 days in a row or for 2 weeks. We've condensed everything down to that remote hearing, and we get right to the witnesses and right to the testimony.
Got it. Okay, so, but there's also a mediation before a hearing, right?
Correct. Mediation in North Carolina is mandatory, and that simply means that it's going to be scheduled. The parties have to attend. They have to participate. There are a few exceptions where mediation would not be mandatory, but the default is otherwise it's always mandatory. It has to be scheduled. The parties have to participate in good faith, And frankly, I'm a big fan of mediation because, number one, it can save a lot of time. It can save a lot of effort and paperwork, because if the parties can really sit down and seriously discuss the issues in the case, a lot of times the insurance company will come around and be intelligent about the claim and about the injuries and about that employee and that worker. And a lot of times they will offer compensation at a sufficient level that my clients may say, Mr. Howard, let's settle this case.
Okay. And mediation is like one sort of big negotiation, right?
Mediation it's less formal than a hearing, but having said that, it is formal in the sense that obviously we have a hard date and a hard time, and we prepare for that date and that time, and when we show up, we have to summarize our position and our case, and we do that for the benefit of the mediator. And the mediator is somebody that's selected by both sides, and both sides agree to that mediator. If there's a scenario where the sides cannot agree who they're going to select as mediator, the North Carolina Industrial Commission will step in and they'll appoint a mediator. But the vast majority of times we actually agree on the mediator. We go to the mediation, we summarize our cases respectively, both the plaintiff and the insurance company and their defense attorney. And then the mediator will actually they'll motivate the sides and encourage the sides to take a hard look at their own cases and to try to find some common ground. And a lot of times I'll even tell my clients, listen, there's no such thing as wasted time at a mediation. Even if the case is not resolved, even if it's not settled, we come away from that process knowing a lot more about the other side.
Right.
We know what they're saying about your claim and your case, and we know what the strengths and weaknesses are. And
a mediator, or that neutral party that sort of not coaches, but coaxes, we'll say, the two other parties, they're an experienced attorney, right? They're someone who's retired or had practiced for years.
That is typically the case. If you're a mediator in North Carolina, number one, you've gone through some formal training, but more importantly, that probably means that you're very experienced in that field of law. The mediators that we typically use in this area for our workers' compensation claims have either practiced in the field for 20 plus years, or they've actually been a deputy commissioner, and they've worked in Raleigh. They've held hearings for perhaps hundreds of cases.
Right. They're
and very
certified, probably.
Exactly.
Okay.
Exactly. So another question that I get quite a bit, one of my clients will call me up. They're in the middle of their treatment with the physician. They have an appointment coming up, and I have to tell them, hey, there's going to be a rehab nurse appointed to your case. That rehab nurse is going to go with you to the next appointment. What else do we tell our clients in that scenario?
I would tell my clients, one, be careful, because the rehab nurse at the end of the day gets their paycheck signed by insurance companies. So I would tell them, be weary of this rehab nurse. And I would say, make your own medical decisions. Sometimes these rehab nurses can be very pushy and sort of want you to get better before you actually are better. And sometimes they sort of guide the medical treatment. However, you can, as an injured worker, can kick them out of the actual physician's room. While you're talking to the doctor, the nurse doesn't have to be present. But they're most likely going to tell you that they have to, but that's not true. They don't have to be present. And the nurse case manager also keeps both parties apprised of what's going on in the injured worker's treatment. So it's beneficial, but it also hurts at the same time. I think I would emphasize to my clients that, listen, at the end of the day, you got to remember that this nurse case manager isn't necessarily on your side. They may help some, but they can likely hurt your claim.
One thing I really like to emphasize to each and every one of our clients is when a case nurse or rehab nurse, we call them both things, when they are assigned to your claim and they show up at your next doctor's appointment, do they have the right to be there throughout the appointment? And the answer is no. In that scenario, I remind each and every one of our clients, you can absolutely insist on that confidential communication between you and your doctor. And so if you're meeting with Dr. Smith and the case nurse is in there and you want to ask Dr. Smith some questions, you're allowed to do that outside of the earshot of the case nurse. I tell my clients, ask the case nurse to leave the room, shut the door, and the doctors understand this. They anticipate it's going to happen and they know it's your right.
Darren, is there an effective way to deal with these case nurses?
One thing that I've found over the years, and it's something that we incorporate into our practice, it's a little bit extra time, but it can be very valuable. I actually like to have the case nurses come meet with us in person, and the client doesn't have to be there, but that's an opportunity for me as the attorney to meet that case nurse. I want to find out about their experience level. I want to find out about their philosophy and how many different insurance companies they've worked for. And a lot of times it's a golden opportunity to communicate with that case nurse and let them know, we know where your paycheck comes from, but we expect you to be professional. We expect you to serve our client first and foremost. And what I mean by that, it could be as fundamental as you need to help our client schedule appointments. You need to help our client make sure their prescriptions are filled. You need to help our client make sure that if a doctor wants a test, that you're communicating with the imaging center and that you're scheduling all that. So, there's good and bad to everything, and that's the case here as well. So I emphasize to my clients, use the case nurse to your advantage. Make sure the case nurse does not cross any boundaries. And at the end of the day, the case nurse can simply help document your evidence. Okay, Sal, I've been injured on the job. I'm the injured employee. And let's say last night I went to your website. It gave me quite a bit of information, but didn't answer all my questions. So I decided the next morning, I'm going to wake up, I'm going to call you at the Greensboro office. What can I expect?
Well, when an injured worker does call our office, they can expect to talk to you or I. And when we do talk to them, we certainly highlight whether they actually need representation or not. And when they don't need representation, we're fine with telling them, listen, you don't need us, but here are the next 3 steps to advance your claim.
Well, that's a good point, but I don't want to be too emphatic about that point. In my years of practice, I've found that with a lot of these sophisticated insurance companies, when and if you need an attorney, you really need an attorney. But you're right, there are some cases where you don't, and many a time you and I have been on the phone and we've listened to the facts and circumstances of somebody's case, but they just don't need us at that point in time. So, well, Sal, thank you for being here today. I certainly appreciate your time, ladies and gentlemen. I hope this was valuable. I hope there was some good information. If you have further questions, please do not hesitate. Give us a call.